Good morning, this is John Lynch of Lynch Solicitors in Clonmel. This morning, this is another one of our COVID-19 videos. And on this particular video, I'd like to talk to you about living together, or cohabitation as it is called. Now, under a piece of legislation in 2010, they recognised, it's called Cohabitation Act, they recognised certain rights to people who are living together. Now, in order to have those rights, you need to be a cohabitant, you need to be a qualified cohabitant, and you also have to fulfill certain other criteria. But just let's start with what is a cohabitant. Now, a cohabitant is literally two people who live together. Living together doesn't necessarily mean living together all the time, but in order to qualify, you have to be living together for a period of 2 years if there are children, and 5 years if there are none. Now, an interesting point about that is that that 2-year period has to be continuously living together. In other words, you can't have a break where you separate, go your separate ways, and are no longer a cohabiting couple or no longer a couple. The first part of the equation is that you are in fact a cohabitant. And a cohabitant, as well as someone who's people who are living together, you have to be living together in a committed relationship. And that's kind of a sine qua non of being entitled to seek redress under the legislation. Being in a committed relationship, an intimate and committed relationship. Let's just deal with the intimate side first. Basically, what the legislation says is the fact that you're not having sexual relations at the time of the application isn't the key thing. You must have had or be having a sexual relationship in order to qualify. So that, by definition, means that if there is no sex in the relationship, then you will not qualify as a cohabitant under the Act. The next part of the equation is that in order to qualify, so if you fulfill the criteria that you're in an intimate and committed relationship, and that's a matter of fact to be proven, and the legislation gives a certain amount of indicators as to what that means. In other words, that, if you are involved in minding children together, if you take on the role as parent of the other person's children, if you have shared finances, if you've joined purchases, and if you hold yourself out as a couple to everybody and anybody that you meet or that you deal with. There are some of the criteria that the court will use to kind of tick the box to say that you are in an intimate and committed relationship. As I said, the other part to it is that it has to be 2 years and or 5 years. And another interesting observation under the legislation is that if you are, let's say, in another relationship, i.e. if you were married, that you have to be entitled to apply for a divorce before you get into a position that you can be a qualified cohabitant. So in other words, you can't be both. You can't be legally still married and also be, if you like, running up time in terms of an intimate and committed relationship. Of course, it doesn't mean you can't have an intimate and committed relationship, but it means that the time limit of the 2 years doesn't start to run until, if you like, you're entitled to apply for a divorce. So under the current legislation, you're talking about a 2-year time period from the date of separation or from when you're separated, and or if you're in a situation where you are able to apply for a divorce but haven't applied for it yet, as long as you qualify, i.e. that you are able to apply for a divorce under those circumstances, you can also be in an intimate and committed relationship. The last part of the jigsaw, or the last element to this, is that depending on whether or not, and there are two circumstances in which somebody might look for redress or look to the courts for some sort of a remedy, and that is either the other party dies and you're applying to their estate, or the relationship has broken down. Now, just bear in mind, by the way, that there is a time limit within which you can make an application, either to somebody's estate or to them personally if the relationship has broken down. And that, generally speaking, is a 2-year time period. So you have a 2-year window within which to do something about it. In the case of somebody dying, it's a 2-year window from the date of not so much the date of death, but the date of extracting the grant. But it's a little bit more complex than that, and I don't propose to go into it all in this video. But anyway, let's assume that you're within your 2-year time frame. Under those circumstances, if it's a breakup situation, in other words, if the relationship is broken down, you must also fulfill, or if you like, pass a test that you're financially dependent on the other party, either as a result of the relationship or because the relationship has ended. So the general gist of that is that you must prove financial dependency on the other party before you're able to make any claim against that other party. And the types of claims that you're talking about are claims against pension, claims against property, maintenance, and the usual, maybe a lump sum order. They're the type of, if you like, remedies that are available to you. So just to wrap it up, there are 2 scenarios: death, breakup of the relationship. You have to prove financial dependency in the case of a breakup scenario. In the case of the claim against the estate, you don't have to do that. There are certain dissimilarities between the two in terms of qualifying, insofar as, there are different considerations that might come into play in both scenarios. And there are certain things that will be consistent, i.e., income levels of both parties, contributions made by both parties, whether there are children and dependents, whether they shared resources, whether they shared investments and various things like that. So, but in the case of an intestacy, in the case of where somebody dies, in those circumstances, you also have to take into account the rights of other people who might benefit from the estate of the deceased. So, the final point about all of this then, of course, and it's my usual wrap-up point when we come to cohabitation or in fact marriage, is that you can enter into a cohabitation agreement which effectively will cover a lot of the elements that we're talking about: maintenance, property rights, succession rights, rights against pensions, etc. So you can actually enter into an agreement and deal with those elements of your relationship, and that agreement is recognised by the law.